Today we're going to be going over general elements of criminal liability. So, this is in section B of paper 1. So this video is specifically for OCR, so we are going to be looking through their specification. So we will look at Actus Reus, and this is what falls under it, which we will be discussing, and mens rea, and we will be discussing these topics that go under it. So just a quick tip from me, this topic itself does not have an essay structure, but it is crucial to understand because it helps your understanding, especially when essay writing, and it comes up a lot in cases in essay writing, so it helps you hit those top grades. The most simple way that I can put this is we have to understand these two important definitions. So these will be Actus Reus, and this means physical element of the crime. So this would be like stealing, just the act itself. And then we also have mens rea, which is the mental element of the crime. So this would be something like planning to steal. So most crimes actually require both Actus Reus and mens rea, but some don't require mens rea, and these are called strict liability offences. And there are other factors that go into it, which we will be discussing. So conduct and consequence crimes. Essentially what this means is that Actus Reus has two types. This is conduct crimes, and these focus on what the defendant actually does. So drink driving, even if nothing bad happens as a result. Then there's consequence crimes. These require a bad result to happen. An example would be murder without the actual harmful effect, so this crime is incomplete. We have voluntary acts and state of affairs. So voluntary acts is for someone to be held liable. Their acts must be voluntary, so that means that they were in full control. A good case for this is Hill v. Baxter. The court held that involuntary actions do not lead to liability. And in this case, it wasn't the defendant's fault that they got attacked by bees, causing an accident. However, sometimes just being in a situation is enough to hold you liable. And what do we mean by this? Well, we can see this in the case of R.V. Larsener. In this case, the defendant was deported back to the UK against their will, and they were found guilty of trespassing because they weren't allowed to be in the UK. Now, you may have already heard this word, but what is an omission, and how can someone be guilty without actually committing an act? So firstly, let's actually define omission. So in some situations, failing to act can lead to liability just because the person had a legal duty to act. So for example, this can be a special relationship like child and parent, seen in R.V. Gibbons. We can see this in when there is a contract, seen in R.V. Pitwood. Also, when there's a statutory duty. An example is the Theft Act 1968, when someone voluntarily takes responsibility of another person, when someone creates a dangerous situation, and lastly, when someone in an official position fails their duty, for example, police. Next is causation. This essentially means that prosecution has to show that the act caused the result. There are two types that you have to talk about, and both of these have to be proved in order for the defendant to be guilty. This is factual causation, where we use the but-for test. So would the harm have happened without defendant's action, seen in R.V. White. In this case, the defendant poisoned their mother, but she had a heart attack before, so therefore he wasn't liable of her death. And then there's also legal causation. So was the act a significant part of the result? And it has to be a major one. We see this in R.V. Paget. The defendant here used his girlfriend as a shield from shots, and the courts ruled that he was guilty of her death. However, we have to think that not all cases are the same, and causation can actually break if there is a third party that does something unforeseeable, such as in R.V. Jordan, where medical treatment was grossly negligent and it therefore became the doctor's fault. The next one is that the victim does something that is bizarre or disproportionate. And very rarely a natural event can intervene if it's unpredictable. The next part is going to be on mens rea. So in mens rea, there are two types of intention. There's direct intention, where the defendant acts with a certain aim of causing a certain outcome or consequence. This is seen in R.V. Mohan. In this case, it was established that direct intent involves making the decision to cause a result, even if it's not the desired result. There's also oblique intention. This is where the defendant doesn't want the consequence to happen, however, they are aware that it will happen. This is seen in R.V. Willin, where the court stated that the jury can find intention where consequence was known by the defendant. Next is subjective recklessness. Now, mens rea itself doesn't mean necessarily that the intention was pre-planned. Sometimes just taking an unjustified risk is enough, and this is called being reckless. Now, the reason that the defendant can be guilty is because they took this risk consciously, and that's enough to amount to recklessness. When this does happen in a case, it is subjective, so courts have to consider what the defendant actually thought or knew in the situation. A good case is R.V. Cunningham, where the court held that someone is reckless if they foresee the risk but still go ahead. In many cases, negligence and gross negligence can be a big part. So let's define negligence. This is when a person fails to meet a standard of care expected by a reasonable person. This is in both criminal and civil cases. Now, gross negligence is similar to negligence, but it's a much more serious breach, as it's a breach of duty of care, which is so serious that it amounts to a criminal act. We can see this in R.V. Adokomo, where the defendant had a duty of care which was breached, resulting in death, so they were held liable. Now, we briefly touched on this, but strict liability offences, these are the offences that do not require mens rea, and this means that the defendant can be guilty even if they didn't mean to do the risk or they didn't foresee it. Courts also have to consider the seriousness of the offence. In Gammon Ltd v AG, they set out guidelines for when strict liability applies. Next is transferred malice. I'm sorry for the wrong spellings. This is when the mens rea is transferred from the intended victim to the actual victim. An example and an easy way to put it is if D throws a punch to A but hits B, then D would be guilty of assaulting B. This case is represented in R.V. Latimer. Lastly is coincidence of actus reus and mens rea. So in order for there to be liability, mens rea and actus reus have to occur at the same time. In some cases, there is a gap between the two, which may result in the defendant actually not being guilty, but it just depends on if it's a continuing act. So that's it for today's video. Thank you for watching. Please like and subscribe. It really helps. And I've been really busy, but I will be posting every week from now on.